though it's well established that employees don't have to keep their protected religious and philosophical beliefs to themselves. They have a right to express those beliefs in the workplace, however offensive and distasteful they might be. You can't just sack someone because you disagree with their opinions. I think that's a conversation we've all had with our clients at one time or another. So the biggest case to come out of the appeal courts in the last 12 months is, in my view, the Higgs and Farmor school case. Those of you who attended the conference last year will remember that I did a whole talk about gender-critical beliefs in the workplace. And at the time, I believe this case was on its way to the Court of Appeal, but we hadn't had a decision just yet. So by way of background, Kirsty Higgs was a Christian school counsellor, and she posted all about her beliefs on Facebook, the fact that she felt that schools were recruiting children for the transgender roster, that children were being brainwashed, things to that effect. And she was dismissed on the basis that she was transphobic. And she brought a claim for discrimination on the basis that no, her beliefs were protected, and she therefore had protection against discrimination. And she won, and the EAT said that employees with protected beliefs are entitled to manifest their beliefs, and an employer can only take action if manifestation is objectionable and dismissal is proportionate. So the EAT sent that case back to the Tribunal for further determination, and Ms. Higgs appealed to the Court of Appeal, and she said, no, you should have just upheld my claims. And the Court of Appeal agreed, and they substituted a finding that her dismissal amounted to unlawful discrimination based on her protected philosophical beliefs. So effectively, the court held that dismissal of an employee merely because they've expressed a religious or protected belief to which an employer objects will constitute direct discrimination. However, if dismissal is not motivated or is motivated not simply by the expression of the belief, but something objectionable in the way that it's expressed, then dismissal will be lawful, but only if the employer can show that it was a proportionate response to the objectionable feature. So for example, that could be if you have a teacher who's refusing to use a student's preferred pronouns, that could potentially be an objectionable manifestation of a protected belief, for argument's sake. But in this case, Ms. Higgs had posted these messages to her private Facebook page. She was quoting from various sources, and I believe she was using her maiden name when she was posting. So the court found that in all of those circumstances, dismissal was not justifiable. So the case underscores the importance of context-specific assessment. Obviously, we're all always talking about context-specific assessments in these kinds of dismissals. So because something that could be unproblematic if expressed on a private social media page could be entirely different if it's communicated in the workplace. So for example, interference in the expression of a protected belief should be done in the least intrusive way. The content, tone, extent of the statement or the action are relevant, the likely audience are relevant, also the nature of the business, all relevant factors. So there are a couple of cases that are on their way through the appeal courts at the moment that are also quite interesting. So the first one that I've set out here is Miller and University of Bristol. This was a case which you all might have heard of. A university professor was dismissed for expressing views on Zionism. And he expressed those views in lectures and in his handouts, in his course materials. And a load of students complained about this, and he was dismissed. So the tribunal found his beliefs were protected and his dismissal was unfair. The university has appealed, so it will be interesting to see, and I think the appeal was heard earlier this week, we don't have a decision just yet, but it will be interesting to see whether the court distinguishes that case from Higgs, again, because of the nature of the manifestation. So we'll wait and see when they come back with that. The other one is Lister and New College of Swindon. So this was a case involving a teacher with gender-critical beliefs. They were dismissed for not using a student's preferred pronouns. Again, arguably, an objectionable manifestation of protected belief. So the tribunal found the individual's beliefs were protected, but upheld the dismissal as proportionate. And Lister has appealed. The EAT is expected to hear that case later this year. So again, it will be interesting to see what the tribunal says about that, particularly in the context of the line of authority that we've had recently. So the next topic that I'm going to be looking at is sexual harassment that takes place on the way to work. And the case is AB and Grafters Group Ltd. So this case comes as the new statutory duty to prevent workplace harassment that we're all familiar with, the one that came into effect in October last year. That's led to a 39% uptick in harassment calls to ACAS over the last 12 months. So very important to have eyes on cases like this going forward. So in this case, a worker believed that she was scheduled to work at Hereford Racecourse, and after missing the transport that was put on by the employer, she accepted a lift from a colleague who had previously driven staff to shifts, and the employer was aware that she had that this individual had driven people to work before. But instead of taking her to work, he sexually harassed her until she was able to escape and call the police. So the tribunal agreed that harassment had taken place. That was very easy and straightforward, but ultimately dismissed the claim against the employer, saying the colleague wasn't acting in the course of employment. But the EAT disagreed, and the EAT found that the tribunal had failed to apply the correct legal test that's referred to in all the established case law, and particularly the case of Chief Constable of Lincolnshire Police and Stubbs, which allows for acts outside of work to be classed as work-related if there is a close enough connection. So the key question for the tribunal was the lift and the harassment that took place during the lift an extension of work? And the EAT found that the harasser had sent sexual messages while on shift earlier. So while he was clocked in, he was harassing this claimant. The only reason she was in his car was work-related, and workplace lifts had happened before, and the employer was aware of that. It was an accepted practice within the workplace. So for all of those reasons, the claimant ultimately succeeded in her claim. And the key takeaway from this is that course of employment is quite broad. So harassment outside the work, on social trips, even journeys on the way to work, can put employers on the hook. And as I've said, it's very important to have eyes on what the higher courts are saying about this sort of thing, given the new duty to prevent harassment. Okay, so I'm going to speak to you now very, very, very briefly about For Women Scotland and the Scottish ministers. We've all done this to death. It was international news over the summer. I'm just touching on it because I think there's still a little bit of confusion about what this case means and what the implications of this case are. So, as we all know, For Women Scotland is a feminist organisation, and they challenged the statutory guidance that was issued by the Scottish ministers under the Gender Representation on Public Boards Act. And they challenged it because the guidance stated that a trans woman with a full gender recognition certificate, which is very important for the purposes of this judgment, should be treated as a woman for the purposes of achieving their gender representation objectives. And For Women Scotland argued that this interpretation was unlawful and it was outside of the legislative competence of the Scottish Parliament. So what that means is this was effectively an exercise in statutory interpretation. The Supreme Court analysed the definitions of sex, man, woman, in the context of the Equality Act. And they concluded that but the terms refer to biological sex, as we're all aware. The Supreme Court found that interpreting sex as certified sex would create incoherency and unworkable provisions, particularly in relation to things like pregnancy and maternity discrimination, single-sex work services, and sports. And it also noted, the Supreme Court noted, that conflating gender reassignment with certified sex could effectively create two subgroups within the protected characteristic of gender reassignment, and it would mean that there would be greater rights to trans people who had gender recognition certificates versus those who did not. So the key takeaways from this case are that while the decision emphasises biological sex within the context of sex discrimination, it doesn't diminish the protections available to trans people under the Equality Act. Trans individuals remain protected from discrimination based on gender reassignment, and of course they can still bring claims for discrimination on the basis of associative and perceived discrimination. That is the key takeaway in my view. Now, the ECHR have put together a draft code following a public consultation. That's currently with the Minister for Women and Equality for approval. It's obviously going to give some guidance on what we can do following this judgment, basically. They issued some pretty dodgy interim guidance. Some of you might have seen that somehow managed to offend absolutely everyone. So hopefully they'll do a better job on the final product. So watch this space. Okay, so the next case I'm going to speak to you about is of importance for part-time workers, and it's Augustine and Data Cars Limited. So in this case, Mr. Augustine, he was a part-time hire car driver for the respondent, and he basically paid a circuit fee to the respondent for access to their dispatch booking system. But the problem was that the circuit fee was the same for all drivers, regardless of whether they were part-time or full-time workers. And Mr. Augustine took exception with this, and he brought a claim that effectively this fee was contrary to Part 5 of the part-time worker regulations, because the part-time workers had to pay a higher fee per hour than the full-time workers. So causation in this context means showing that the less favourable treatment was because the worker was part-time. The law requires that connection. But as some of you might be aware, there is a notable conflict in the case law regarding the correct test for causation. So the appellant in this case contended that the proper approach to causation was as set out in the EAT case of Farmor and Manchester City Council, namely that less favourable treatment under the part-time worker regulations will be made out if a worker's part-time status is an effective cause, even if it's not the sole cause of the less favourable treatment. However, the respondent in this case contended that the correct approach was as set out in the case of McMenemy and Capita Business Services Limited, namely, it was necessary for the worker to establish that the worker's part-time status was the sole cause of the less favourable treatment. And this flowed from the use of the word solely in the part-time worker directive. So in this case, Mr. Augustine lost at the Employment Tribunal. They found that he'd not been subject to a detriment based on his part-time worker status, as the fee applied equally to full-time and part-time workers. And so they applied the test in McMenemy, the sole cause test. So he appealed to the EAT, and the EAT found that the EAT was wrong to find that the fee did not amount to less favourable treatment of part-time workers, but it nevertheless dismissed the appeal, and it determined that there was potential for the fee to amount to less favourable treatment, but it felt bound to apply the test in McMenemy. As such, the Menemy test was not met in this case. He then appealed to the Court of Appeal, who also dismissed his appeal. It was quite interesting because Lord Justices Edis and Bean considered that actually the test in McMenemy was wrongly decided, and they approved the analysis in Farmor, but they considered it nevertheless appropriate to apply McMenemy in the interest of a single consistent approach to the proper interpretation of the regulations. So that means that they've effectively left it to the Supreme Court to resolve this conflict in the authorities. So the question for the Supreme Court will be, does Regulation 5 of the part-time workers regulations apply if a worker's part-time status is an effective cause but not the sole cause of the less favourable treatment? So it's going to resolve the conflict in the case law. Well, it will hopefully resolve the conflict in the case law once and for all. The last case that I'm going to be speaking to you about today is all about employment status, and it's the case of Groom and Maritime and Coast Guard Agency. So here, the EAT was asked to consider whether a volunteer in the Coastal Rescue Service could be a worker in relation to activities that he performed personally. So by way of background, Mr. Groom was a volunteer coastal rescue officer, and he claimed worker status after his membership was terminated, even though he was working under a volunteer agreement. And while some of the activities set out in his volunteer agreement were unpaid, he was entitled to be paid for other activities if he submitted a claim for payment to the organisation. So Mr. Groom was subject to some disciplinary proceedings, and he sought the right to be accompanied at a disciplinary hearing. And as we're all aware, that is a right under the Employment Rights Act that is granted only to employees and workers. So to be classed as a worker, Mr. Groom needed to demonstrate that he had a contract or other arrangement to undertake work or services personally. And the Employment Tribunal ruled that he wasn't a worker, as their finding was that there was no contract between Mr. Groom and the respondent when he attended to activities. Interestingly, our very own Paul Kerfer at Trinity Chambers represented the claimant at first instance, so there we go. However, when the case made its way to the EAT found that he was a worker when he was engaged in those part-time activities, regardless of the fact that he was generally considered to be a volunteer and carrying out services under a volunteer agreement. So specifically, they found that there's no firm rule that a volunteer can never be an employee or a worker. The relationships are not mutually exclusive. The fact that Mr. Groom had to claim for remuneration was not a relevant distinction. The right to remuneration was an important factor in the determination, and it had been wrong for the tribunal to discount that simply because he had to submit a claim for payment. And finally, whilst Mr. Groom was carrying out activity to which remuneration was applicable, his work was controlled by the organisation and there was an implied contract in place. We know how important control is when we're having a look at this particular area of law. So each activity triggered a contract coming into place. So on that basis, the EAT found that whilst he was carrying out the work for remuneration in particular, he was a worker.